Welcome back. This is part 2 on the meaning of intent, and I'm going to call this section "A Guy Tosses a Brick." Okay, a lot of things could happen as a result of tossing that brick. It could land on somebody's head. It could land on a cat. It might go out the window and fall through the windshield of a car parked below. We have to figure out whether I intended any of those consequences. So the first issue is whether the act was intentional, right? Wrong. That act was clearly intentional. It's the result of volition. I consciously did the act. The thing that we've got to concern ourselves with is whether or not I intended the consequences. Now, instead of having me sitting here in my office, let's put me on the second floor of a building where I'm laying bricks. And say I toss the brick aside like I just did because there was a crack in it and I can't use it. And as we said, there's possible consequences might be that it hit somebody in the head. We would call that a battery, as we'll learn next week. It could hit a cat. That would be a trespass to chattel, which is a tort to the owner of the cat, by the way, not to the cat himself. Or it could smash through the windshield of a car parked below, which would be trespass to chattel again. So to determine whether or not I'm liable, we need to ask what was my intent. To be clear, this is a subjective test. We are actually trying to go into the mind of the actor and determine what his intent was, what his purpose was. So the question is, when I tossed the brick aside, did I do it for the purpose of hitting some guy on the head? Well, no. Did I act for the purpose of hitting a cat? No. Did I mean to throw the brick through the windshield of a car? No, I didn't. So the question then becomes, if that was not my purpose to cause any of those consequences, did I know to a substantial certainty that I would hit the guy on the head? Did I know to a substantial certainty that I would hit the cat or break the windshield? If it cannot be said that I knew that those things would happen, then none of those consequences are intentional, and I'll not be liable for them, at least on any theory of intentional torts. Now, it may be that I acted carelessly, that I recklessly created the risk of those kinds of harms, and we'll learn later that in the area of negligence, I can be held liable under that theory. But none of those consequences on the facts that I gave you could fairly be characterized as intentional. Or to be more precise, can fairly be characterized as having been intentionally caused. Let's make another point now about the meaning of intent, and that is that these definitions are alternatives. Get my marker out here. We act with the intent to cause a particular consequence if you act for the purpose of causing it, or knowing that it was substantially certain to result. So you have the purpose or knowledge. You need one or the other. You don't need both. Since there's nothing to be gained by combining these, just stick with one or the other. If the facts clearly show that a person acted for the purpose of causing a harmful contact with somebody else, they punched them in the nose, they threw a rock at their head, that's enough. You can stop and say that they acted with the necessary intent. You don't have to go further and say that in addition that they knew that the consequence was substantially certain to result. If I heave a rock at you and you're on the other side of the parking lot, the chances of me hitting you are pretty slim. So it really can't be said that I knew that I would hit you, but that doesn't matter because it was my purpose. So it's one or the other, not both. All right, let's get the ink off here. Let me see, and make a couple of final points and wind this up. A case in which the defendant acts for the purpose of causing harm to the defendant is our paradigm of an intentional tort. A purpose, intent, or paradigm, that's what I think of as number one here on our definition. When you don't have that, it's when we have to drop down to this second part of the definition, knowing that the consequence is substantially certain to result. You should appreciate that that's sort of a fallback position. Where we don't have a paradigm case, we are going to treat the defendant as if he intended the result if he knows that it's substantially certain to result from his act. Now, let's make sure we appreciate this point. Knowledge that something's going to happen means just that. You have to have evidence the defendant knows that it's going to occur. I've got several statements up here, 3 statements that all of which, as it says, are serious misstatements and call into question your understanding of this principle. If you find yourself writing one of these, stop. The defendant should have known that harm was substantially certain to result. Now the problem with that is should have known. What someone knows and what someone should know are different things. We'll deal with what risks that the defendant should be aware of in the area of negligence. We're not talking about what somebody should have known. We're talking about what they knew. Likewise, the defendant knew to a substantial certainty that harm was likely or possible or even very likely to occur. You've confused knowledge that it's substantially certain to result with knowledge that it's likely or that he's created a risk or it's even very likely. That's different than knowing that it's going to happen. Even the defendant knew that harm could result from his act. We're not talking about what you knew could result, but what was going to result. Knowledge means knowledge. And don't say that the defendant knew that a consequence was substantially certain to result when all he really did was create an unreasonable risk of it or acted recklessly or created the possibility or even the likelihood that it would occur. What we're looking for is knowledge. So the last sentence here, an act that is not done with the intention as we've defined it, that is, not done for the purpose of causing the consequence or knowing to a substantial certainty that the consequence would result. If we don't have that, the act does not make the actor liable, even if the act involves an unreasonable risk and therefore would be negligent or reckless. So, when I'm up there on the top of the ladder tossing a brick over my shoulder without looking or paying attention to what's going on down below me, I'll probably be liable, but not for an intentional tort, because I haven't acted with the intent that's necessary to impose liability.